Joining us now, defense attorney and legal expert Whitney Boan. Whitney, I got to ask you, when we saw this happen today, what type of challenges can we expect for someone to defend themselves, represent themselves legally in a case like this?
Well, I think one of the major challenges, and it was raised by Judge Bigney at initial appearances today, is this is an extremely serious and complex charge, or charges, I should say. And we're talking about a case that very likely could end up becoming a death penalty case, although that hasn't been spoken in terms of being the gospel yet or not. So there's going to be some real challenges in terms of, is this person going to be able, Mr. Loyd, be able to handle his own defense in a manner where he's going to represent himself and it be a trial that should go in terms of everybody having their day in court, including him, including the victim, in terms of the victim's family, the state, etc. It's going to be a complicated situation, though, if he does represent himself, I will.
Yeah, and assuming he doesn't have legal training, how do you expect this to look actually when the criminal proceedings take place, watching it compared to a quote-unquote more normal trial situation?
In my experience, and I have observed a few trials where defendants represent themselves or pro se defendants, it typically takes a little longer in terms of sometimes the judge has to be a little more patient, take a little more time in terms of explaining things to the defendant that maybe if an attorney was involved, they wouldn't have to. And that doesn't mean the judge can do the defendant's job for them in terms of representing them, because the judge has to remain fair and impartial to both the state and the defense. However, I think that you could expect that it will definitely be a circus either way, regardless of whether or not Mr. Loyd represents himself.
Can he still change his mind at this point and request counsel to come in a week, 2 weeks, a month down the road?
Absolutely. There's some authority that a defendant cannot elect the right to represent him or herself once a jury is already impaneled. So we're talking about in the trial, although even then there's some split authority about that in terms of maybe a defendant even can do it that late in terms of they can elect to represent themselves or not. However, I would expect in this case, Judge Lawton, who's the trial judge assigned to handle this case, will probably be making inquiries at each and every stage of this case of Mr. Loyd in terms of, do you understand what you're doing? Can you voluntarily waive your right to counsel in a way that I'm satisfied that you understand what that means to waive your right to counsel and that you understand the consequences of what you're doing?
All right, defense attorney Whitney Boan, thanks for your time and insight as always. We appreciate it.